The Law number 17 of 2018 provides an alternative to imprisonment in certain offences. Instead of giving a jail term or police custody, the convict or the accused will be given a wearable electronic device capable of monitoring the real-time location of the person wearing it. The use of this electronic device as a monitoring tool is allowed for a temporary period, instead of a police custody or a replacement of a criminal conviction resulting in an imprisonment sentence. The movement of the person wearing this device may be restricted to his house or a particular geographical location. With the introduction of electronic tagging, the prosecution may have the discretion to give bail to the accused and restrict his movement through this device. Moreover, even upon the judgment, the court could implement the same procedures as a replacement of the sentence. When the accused is referred to the court under electronic monitoring, the accused has the right to request the court to terminate his electronic monitoring if the case is not accepted by the court. Moreover, if the accused is only punished with a fine, he has the right to request the execution department to reduce the fine amount for each day spent under electronic monitoring. The person wearing the device may be allowed to continue his professional practice, training, education, medical treatment, and any other activity as the competent authority deems fit. The police have the authority to supervise the execution of the electronic monitoring by checking the integrity of the device and accordingly submitting a report to the competent prosecution. Moreover, the person wearing the device has the right to report any health issues caused by the device to the prosecution. Electronic monitoring may be allowed only in certain offences. However, the application of electronic monitoring is impossible in crimes with mandatory deportation sentences, such as drugs, sexual and honour-related crimes. The criminal court may replace the jail sentence of less than 2 years of imprisonment with the electronic monitoring, if the court is satisfied that the convict is unlikely to commit the same crime again, along with other factors, such as permanent place of residence in the UAE due to education or regular work activity, or being a sole breadwinner. However, electronic monitoring is not applicable for habitual offenders. Any person under electronic tagging has to keep the competent authority informed on his whereabouts and any change in his location. He is not allowed to leave the country unless approved by the competent authority based on his circumstances, and any period outside the country shall not be calculated as under electronic monitoring. Any criminal who had been sentenced to imprisonment between 2 to 5 years before the new law and has served half of that period may request the prosecution to place him under electronic monitoring for the remainder of the period. However, the prosecution has the discretion to review and approve such requests on a case-to-case basis.
To receive more informative videos from our channel, click the subscribe button and press the bell icon. Please feel free to like, share, or leave a comment or question which will be answered in our next videos.